Hello, everybody, and welcome to this edition of Macro Pro and Friends. In fact, today it's kind of a special edition because it's for you in Texas. So my name is Diane Cohen, for those of you who don't know me, and I am the Vice President of Client Relations for Macro Pro. I'm in charge of these webinars, and I'm helped by Mandy Farquhar of our office today. Now, if you don't know who Macro Pro is, I'd just like to tell you a little bit about us and what we do. We're a national document retrieval company. We can help you secure records for your claims and litigated files. So today I am accompanied by Mandy Farquhar and Tom Rennick. So I would like to introduce you to them. Mandy, how are you and how are things going?
Great. I wanted to let our listeners know, they might want to know that MacroPro has secured records from every state in the union and 33 countries and on six continents. Pretty amazing.
Oh, it absolutely is. And that's a really excellent point. So how are things for you as far as getting out nationally?
Great. It's been great getting out and seeing familiar faces and even new faces. I've been to a few conferences, a few client visits and lunches in the past few months, and happy to see everyone again. Can't wait to get out to Texas to see some of you, and of course, Mr. Tom Rennick. I'm also looking forward to the conference in Galveston in October, so I hope to see some of you there.
Now, Tom, I understand you're going to be at that conference as well. Can you tell our audience what you do for Verisk?
Yes, thank you so much, Diane, and I'm looking forward to seeing you as well, Mandy. We are very happy to be here today for the session. It's really great to be able to join everyone. My name's Tom Rennick, and I'm the local area account manager for Texas and all surrounding states for ISO Claims Partners. I serve our clients by acting as a primary point of contact for Medicare compliance related questions and for processing the day-to-day referrals. I also serve as the liaison between clients and our services team to ensure the best fit solutions are being utilized by each of you. It's great to see so many familiar names on our list attending the webinar today. For those of you that I haven't previously met, I look forward to the opportunity to connect with you, and even more, I can't wait until we can be back together again in person, hopefully sooner than later.
Absolutely. Well, before we get on with the introductions of our speakers and our presentation, we have just a little bit of housekeeping to take care of. So the first thing is, if you have any questions for our experts today, there is a question chat box that you can ask questions of our experts. Please make sure to type in your questions, and Mandy and I will be happy to ask those questions. And then in addition to that, there are handouts, right, Mandy?
Yes, attached to the webinar page on the right-hand side, you will find the presentation and newsletters from Mark and Sid that are jam-packed with some great information in regards to Medicare compliance. Please download them before this webinar is over.
There's also a little information about MacroPro as well, so if you don't know about us, that you've got a little bit of reading. And then lastly, I'd like to say that we have an encore performance on the MacroPro YouTube page, so you'll be able to see this next week on YouTube. I have nothing else to say, so I am going to turn this over to Tom. So Tom, thank you very much.
Well, thank you so much again, Diane. Before I turn it over to our panel today, please allow me just a brief moment to provide you some background on ISO Claims Partners. As most of you know, we are the industry leader in providing proven and cost-effective Medicare secondary payer compliance. Our client base includes 21 of the top 25 workers' compensation carriers and all of the top 10 property and casualty insurers in the country. We offer a full suite of solutions and services to improve claims outcomes, to keep you compliant, and on top of all of that, to save you money. Whether it's Section 111 reporting, conditional payment recovery, medical cost projections, Medicare set-asides, professional administration, or even all of the above, you can trust our many years of combined experience and our legal expertise on each and every file. So thank you again. There is a lot to cover today, so I'd like to now introduce you to our ISO Claims Partners panel, who will be presenting for you. So first, I'd like to introduce Mark Popolizio. He is our Vice President of Medicare Secondary Payer Compliance. Many of you may know Mark from his workers' comp and liability defense litigation days, including his regular articles and webinars on Medicare issues. Mark has been knee-deep in Medicare compliance since 2001. He is a regularly featured presenter at national seminars and has authored numerous articles addressing a litany of topics related to Medicare secondary payer compliance. Joining Mark today is Sid Wong. He is our Vice President of Medicare Policy. Many of you already know Sid from his work with you on your referrals to us. Sid is a policy specialist and a CMS trench warrior. He manages ISO Claims Partners policy team, where he helps evaluate the impact of Medicare compliance on the industry and provides expert guidance to our customers. He also authors industry articles and teams up with Mark on webinars, as he has today. Sid has a truly vast knowledge in so many areas, including Medicare, and I'm so excited for you to have an opportunity to see that firsthand today. So, all right, I think that covers it, gentlemen. I know you have a lot on the agenda for our group, so Mark, let's have you take it away.
Oh, thank you so much, Tom. Good afternoon, everybody. Thank you for attending today's event. And Mandy and Diane, thank you so much for inviting us to do the presentation today. Sid and I always look forward to do a Macro Pro event. It's a very impressive company. I've learned a lot about Macro Pro over the past year. And Mandy and Diane, just wonderful to work with. So it's always a joy. So we look forward to the session today. We thank them for inviting us, and always good to work with my good buddy Sid, who's sporting a new set of spectacles over there. He's looking great. Okay, I'm getting myself a pair after this, I think. But if you look at our title slide today, Texas Medicare Roundup, the latest CMS updates and claim strategies to stay compliant. So we're gonna go around the horn with some refresher things, but some other stuff that is in the hopper, brewing with CMS. There we are again. Okay, I can do no better than what you see on the screen. Sorry, folks. Okay, but let's look at today's focus points. So we're gonna have a Texas focus around Medicare level set. Okay, whether you're a non-subscriber, subscriber, a liability carrier, a no-fault, med pay, wherever you are in the non-group health space that involves injuries or claims for injuries, that involve Medicare beneficiaries, et cetera. You know, Medicare has application, and that's where we're going to address today. And that's what we're going to address today. And where necessary, if we need to thread the needle sometimes between certain categories of insurance, et cetera, in terms of how CMS approaches them, we will. And especially in Sid's section, you may hear him splitting the atoms here or there a little bit. But let's have big picture thinking. Think about what Sid and I are talking about today from the big picture, okay? And what it is that you're currently doing that you may need to readjust or retool. Now, that could be the individual adjuster who's handling the file right now, or the attorney. That could also mean, bigger picture than that, you know, at the managerial executive level, where are you as a company with respect to your Medicare protocols and processes? Do they need to be revamped? Do they need to be added to, et cetera? We'll hit it all. 111, conditional payments, Medicare Advantage Plans, future medicals. MSA is a sort of a weird area for Texas. We'll call it future medicals, all right? And, of course, there's always the hot topic. Section 111 penalties are around the corner. The PAID Act goes live in December. What is that all about, right? We got an article in the queue over there Mandy was talked about, but we have slides on it. We'll talk about that and CMS's future medical proposals. Where are they? What could they mean? When will we see them? Et cetera, stuff like that. And think about how it is we can make Medicare work better. Sydney, let's move ahead. Let's set the stage really quick. Nuts and bolts refresher. Just bear with me here. There's a method to the madness on the next slide. Let's reacquaint ourselves with some red flags. We know how people get on Medicare: age, 65 years or older. Folks who have been accepted by Social Security disability will get Medicare. End-stage renal disease, Lou Gehrig's disease, ALS. These are the factors or the triggers for entitlement, the red flags that will get a person on Medicare. Now, very important for when Sid and I start to talk about recovery claims, Medicare recovery claims. It is now especially important to not only know whether our claimant, our plaintiff, or to use that term interchangeably, both for, you know, the liability crowd or the comp crowd, et cetera. We now need to know what type of Medicare this person has. So when the person becomes entitled to Medicare, he or she needs to make an election of where they want to get their Medicare benefits from. They can get it through the Part A and Part B sections of Medicare. That's known as traditional Medicare or original Medicare. It's run by the government. It's run by CMS. there's one plan in town, no matter where you sit across the country. That's been with us a very long time, since 1965. 1997, Congress created a new section to the Medicare program called Medicare Advantage, and I like to view this as private Medicare. This isn't CMS, the government providing the benefits. These are private insurers that are providing the benefits, and we'll learn later why people have been gravitating towards these Medicare Advantage plans. But this is becoming hot, especially in Texas, because we got a couple cases that have impact. And then if the beneficiary wants prescription drug coverage, no matter which program they're in, either the governmental program A and B or the private Part C Medicare program, they pick a program from the Part D grab bag, a collection of Part D private insurance carriers that provide the prescription drug coverage. So if you haven't really been determining what type of Medicare the person has, in other words, what program part he or she is in, this is now important to do. And we're going to learn a little bit about the PAID Act later, how the PAID Act will make this easier. Okay, Sydney, let's move it ahead. Let's go to the next slide. This is how simple Medicare compliance is. If you understand the bubbles, you get Medicare. Now, will it be off the rails after this slide? Completely, okay? But partly that's because of the way CMS has administering the program, partly because we have a statute that isn't very well worded or very clear in certain areas. But these are really the four major areas you need to consider. 111, electronic reporting of claims to Medicare. We'll talk about this. Conditional payments. 111 feeds the right bubble to the corner. Conditional payments. Sid will we'll talk about the impact when he does this section, but conditional payments involves paying back CMS for money they paid towards the claimant's medical care related to the claim if they're in the governmental program. If the person's in the Medicare Advantage plan, then we got to worry about Medicare Advantage recovery claim, all right? And of course, there's this idea of the future medical interest, this wobbly idea of the Medicare set-aside, a little bit unique in Texas. Sid's going to break that down for us when we go. But look, each bubble equates to a question you should ask yourself on each file. And if you ask yourself these questions, you really can't miss. You may not know the answer, but you know who to go to get it. Number one, does this case need to be reported to CMS underneath the 111 reporting system? Number two, is there a conditional payment recovery claim I got to deal with? Number three, is there a Medicare Advantage recovery claim I have to deal with? And number four, is there something we need to do with respect to future interest of Medicare, loosely the Medicare set-aside idea? All right, moving ahead. So let's knock it out first. Let's get item number two, Section 111 reporting. What is it? Okay, before I show you where CMS is headed, let's refresh ourselves with what it is, because you're going to hear about it again when Sid starts talking about his conditional payment situations, right? So the key points about the 111 law is electronic. Most of you out there aren't the people pushing the buttons and reporting, but trust me, it's going around you. It's happening around you, okay? And secondly, the major thing you need to take away from it is that Medicare will know about a case if it involves a Medicare beneficiary for the most part. And they know through the 111 law, okay? Certain entities called responsible reporting entities, RREs, are the parties that have to report, okay? Typically insurers, self-insurers, it could be any number of other risk-bearing entities, okay? It is never the claimant or the claimant's lawyer, so we can't shift the 111 reporting responsibility to the claimant or the claimant's lawyer. They've been left out of the law, okay? So it falls on the insurer side. And in the 111 world, they are known as the RRE. That's who report. They either do it themselves or they use a reporting agent. They may use a TPA to do it for them. They may use our company to do it for them. But the responsibility is on the RRE. Now, if you look at the right side of the screen, it's important to get it right, okay? Because if you don't report properly underneath 111, there could be a penalty of up to $1,000 a day per claim. It's pretty hefty. CMS is in the process of formulating their final penalty provisions. I'll show you those in a minute, okay? And secondly, 111 reporting is very important in terms of its accuracy because it impacts conditional payments down the road. And you'll see Sid talk about that when he gets to the conditional payment area. That's why they put the 111 law in for two reasons. One, CMS wants to know about cases that involve Medicare beneficiaries. And two, they take the data that they get and they then start their conditional payment process from it. Okay, let's move ahead. So when does the RRE report in the 111 world? There's two times. Okay, both triggers could be applicable depending on the facts. Maybe only one is depending on the facts. The facts dictate the applicability of the triggers. There's the ORM trigger, ongoing responsibility for medical. It is what it sounds like. This is when the RRE accepts ongoing responsibility for medical. Okay, we see this a lot in the workers' compensation space. We see this a lot in the no-fault space, in the med pay space, right? Where these carriers accept responsibility for injuries and treatment. And if they do, and the claimant's a Medicare beneficiary, their 111 team reports the ORM to CMS. CMS now knows about the case, and they know about which conditions the RRE has accepted. The other trigger, TPOC, total payment obligation to the claimant, is a settlement, judgment, award, or other payment greater than $750, right, involving a Medicare beneficiary. So when we settle a claim that involves a Medicare beneficiary for something greater than $750, that case is a reportable event to CMS. CMS will get all the information they need to know: the claimant lawyer, how much the case settled for, the date it settled for, etc., the alleged codes, all of it. Okay? Could reporting be required in each trigger? Yes, depends on the case. Sometimes it's just one of the triggers. Okay? But this is how CMS knows about your claims through the 111 system. Now, on the next slide, we wanted to acquaint you with some of the ideas or some of the data that gets reported to CMS. Stuff I've already talked about: date of accident, date of injury, Big Five data, claimant's first name, last name, gender, date of birth, social, the insurance coverage information, right? ORM dates, the TPOC dates, the ICD codes that are related to the injuries, etc. So they use all this, as Sid will explain, to drive their conditional payment process down the road. Now, a big thing that's out there right now, our next item for consideration, are the Section 111 penalties. And we'll see here on the next slide. Let's see. There we go. CMS's Section 111 civil money penalties. I mentioned to you that CMS, there's a fine of up to $1,000 a day if you do not report properly. So where are we with the penalties? Okay, well, CMS last winter, February 2020, released their proposals. They gave the industry to April 2020 to comment on them. What was our opinion, right? People could respond, right? We did as a company, along with about 49 other companies, I believe, all right? And right now, we're in a holding pattern. We're waiting for CMS to announce their official final penalties for Section 111. Let me show you what's on the table. Here's what they're proposing on the next slide. First one, CMS is proposing that they penalize RREs in situations where they fail to report the claim, the claim record, the NGHP, non-group health plan beneficiary record, within the required time frame, no more than 1 year after the TPOC. Okay, so the TPOC ORM come into play, right? Okay, look at number 2. The RRE's response to CMS recovery efforts contradicts the RRE Section 111 reporting. We'll have more to talk about this in conditional payments, but this is a big one. What CMS is kind of saying here is you got to have your stuff together. So your 111 reporting has to basically be congruent with what you may claim down the road. For instance, you may have reported in 111 that you're responsible for the right elbow, but down the road, you're fighting CMS over their conditional payment claim for the right elbow. Well, that's going to be a problem if these penalty provisions go in as is. That could result in a Section 111 penalty. Okay, that's a very important one. Number 3, the RRE reporting exceeds CMS's error tolerance threshold, proposed at 20%, in any 4 out of the 8 consecutive reporting periods. So this puts a premium for folks who are the 111 experts on the phone back at your companies. Check your reporting and check your reporting periods and your error tolerance threshold. Okay, are you up against this? Are you over it? Are you good? Right. So look at the resources in the resource area that Mandy talked about. CMS is also going to also has on the table on the next slide a proposed safe harbor compliance. Look, here's the skinny on it, right? So the RREs have to determine the Medicare status of the claimant. And to do that, first name, last name, date of birth, gender, and the Social Security number. Sometimes it's been hard for the insurers, the RREs, to get the Social Security number, right? Claimants won't give it to them. And it doesn't help. CMS runs commercials on TV telling them not to, right? So that's been a problem. So CMS has on the table a compliance safe harbor for those situations. And basically what the screen is saying is if the RRE gives a good faith effort to get those data points that I just mentioned, especially the social, but they're unable to do it, then they would have a compliance safe harbor. If you can just walk down the screen with me very briefly here, the first one talks about going out to the claimant and his lawyer at least twice by mail, at least once by phone or other means of contact to request the info. Number two talks about certifying that they haven't received the response or they got a response that the individual won't provide the data elements. 3 talks about the RREs keeping this documentation on hand just in case CMS asks for it. And 4, again, similar to 3, maintaining these records to show their good faith effort, showing the dates and the types of communications made toward the individual. What I showed you on the previous screen, the penalty proposals, and what I show you here, the proposed good faith safe harbor, are just that. These are CMS's proposals. They could go into law exactly the way I showed them to you right now. CMS could tweak them. We don't know what they're going to do, but Sid and I are monitoring it. So that brings us, Sid, to the next issue I want you to drive. I mentioned it a bunch of times. Item number 4. When a person's in the governmental Medicare Part A and B program, the government Medicare program, there could be issues of conditional payments and Treasury claims. And Sid, if you could take it away for the next set of slides.
Yeah, thanks, Mark, and thanks for the intro. So yeah, that's an important, key aspect to keep in mind, right? What I'm talking about here is going to be the process for federal Medicare. Mark's going to talk about Medicare Advantage in a little bit, but let's dive into this and take a look at this. So, as far as Medicare's recovery right, conditional payments, they have very, very strong rights of recovery, right? So the statute indicates that they can recover from any primary payer and pursue any party that makes or receives the primary payment. So, in the context of Medicare Advantage plan recovery, we've seen them pursue defense attorneys. We've seen them pursue defense firms, claimants attorneys, the whole 9 yards. So Medicare does have very, very strong rights of recovery with respect to conditional payments. As far as the things that Medicare can do to effectuate their recovery, they have a lot of tools in the box, right? So first and foremost, once they issue a demand, if it's not paid timely, interest may accrue. If it's not paid within the appropriate time period, they can also refer the debt over to the U.S. Department of Treasury for collection. From there, they can dole it out to a collection agency for recovery, or they can submit it to their Treasury offset program, which may allow them, in the situations where there may be a federal payment that's owed back to the debtor or the responsible reporting entity, they may be able to go in and offset those dollars based off of the failure to reimburse Medicare for conditional payments. Also, if they choose to, they can also refer the debt over to the U.S. Department of Justice, and so should they choose, they can file suit in federal court to collect the conditional payments. If they do, they can recover for double damages. So again, a significant number of ways that Medicare can leverage their rights of recovery. Also, there's something called a private cause of action as well, which allows again, for those to bring those with stakes on the claim to bring suit to recover for double damages. So as far as how the CMS recovery process works, I think we all think about it in terms of, Medicare is seeking recovery of their conditional payments. However, Medicare actually leverages two contractors to effectuate recovery. First is the Benefits Coordination and Recovery Center, otherwise known as the BCRC. And for those that are handling liability claims, for the most part, is going to be handled through the BCRC recovery process. On the other side of the fence is the Commercial Repayment Center, otherwise known as the CRC. They are tasked with recovering through the ORM reporting. So as Mark had outlined previously with Section 111 reporting, how the accuracy of the data is extremely important with the coordination and recovery of conditional payments. The CRC is going to leverage that ORM response. ORM is yes, is going to signal to Medicare that there's a primary payer responsibility, and they are going to seek recovery based off of that. The BCRC also leverages Section 111 data as well, but they're more concerned with TPOC. So the way that I typically distinguish it is BCRC's TPOC recovery, Commercial Repayment Center is CRC recovery. BCRC recovery, primarily liability claims, CRC recovery, primarily work comp and no-fault claims, which I'll talk about in the next slide. So this is kind of how it breaks down. So I mentioned, how the CRC recovers, some things to keep in mind and some things that are a little bit different than the BCRC handling. So for those that are working with work comp claims, no-fault claims, remember that the CRC pursues the carrier or self-insured first as the debtor. That's who they view as responsible and as the primary payer. Again, looking at that ORM data, right? So if the RRE is reporting ongoing responsibility for medicals, they know primary payer responsibility. As a result, they also require a consent form, or what they call a letter of authority, signed by the carrier or self-insured, right? That authorizes a vendor or a third party to act on their behalf. So, and this is going to differ again when we look at the BCRC and what they require as far as an authorization is concerned as well. The CRC too, their process is, because it's triggered off the RRM, they utilize something called a conditional payment notice. And that differs from the correspondences that you might receive from the BCRC, where the conditional payment notice has a requirement to respond to it within 30 days of the date of the letter. Failure to do so will cause the letter, Medicare will issue a demand 30 days, once 30 days are up. So as far as the BCRC and where that differs, I mentioned the CRC views the carrier and the self-insured as the debtor. BCRC views the beneficiary as the debtor, and they pursue based off of the notice of settlement against the settlement and the settlement proceeds. So what the BCRC requires instead is a signed consent form, otherwise known as a proof of representation form, signed by the beneficiary in order to work a claim on their behalf. So a couple differences between the contractors. I think it's really important to understand who you're dealing with, the type of claim you're dealing with, and understanding the process in order to properly deal with and handle the conditional payments that might arise as a result of that. All right. So this is just an overview of the types of consent forms or authorizations that are utilized and how each provides access to certain information. So the first one is, of course, the letter of authority utilized with the CRC for no fault work comp med pay claims, signed by the carrier and or self-insured, not by the claimant or beneficiary. The proof of representation is signed by the claimant. Both of those will allow for a two-way communication between the contractors and the authorized party. So you're able to request information, Medicare will provide a breakdown of the charges and allow for a dispute or communication between the contractor and the third party. A little bit different is the consent to release. That is primarily for liability claims, requires the beneficiary sign that as well. However, that only allows a one-way communication. So you're not allowed to dispute based off of that, and it's much more limited than the proof of representation. So as far as the letter types, this is one of the questions that we often get, and I think it's important to distinguish between the various correspondences that you might get from the Medicare contractors. So I mentioned previously, there's a conditional payment notice, but first I want to start with the conditional payment letter. That is a correspondence, could be from either contractor, but basically it outlines, that there might be a potential recovery claim. It'll also break down the charges that are associated with a potential recovery claim. So you'll get the information on the beneficiary, the claim information, the injuries that are involved, the dates that the payments were made. So you can make an assessment of what might be related, what might not be, and dispute off of that letter. There's no requirement to pay upon the issuance of conditional payment letter. It's more of an informative document for the parties to utilize. The conditional payment notice is similar to this conditional payment letter as far as the information that's been provided, but that one does have that 30-day time period to respond. Otherwise, Medicare will issue a demand. Now, the demand is Medicare's request, or the Medicare contractor request, to actually make payment or reimburse for the amount that's listed. In all three of these cases, you're still able to dispute any unrelated charges, but the demand is one that actually starts the clock, right? So if that's not paid timely, that's when Medicare can take those other steps, right? Start to tack on interest after 60 days, refer debt over to the U.S. Department of Treasury after 120 days. So the demand is critical, right? And then finally, there's something called the final demand. And where there's OREM involved, you might get multiple demands so long as OREM remains open. What the final demand is, it's a term of art that essentially indicates that this is the last demand that Medicare will issue before they close their recovery claim. So long as the final demand is resolved, then Medicare or the Medicare contractor will close their claim or recovery claim on their end. I just wanted to kind of walk through some of the issues and trends that we've been seeing as far as handling conditional payment recovery. I think a lot of the pain points that you might be seeing in the industry are illustrated here. But first and foremost, I can't emphasize enough how important it is, especially when you're dealing with the CRC, to make sure that Section 111 data is accurate, right? Because they are really driven off of that information. So if OREM should not have been reported but is, and you're trying to argue that no, the workers' compensation claim, for example, is denied, or it doesn't fall within the no-fault coverage, the contractor is going to look at that ORM and say, well, you've indicated here you're a primary payer, and they might refuse to accept the dispute as a result of that. Similarly, if there's ICD codes that are reported but there was an erroneous ICD code included, and you're trying to dispute it, saying that ICD code is not related to the claim, that's another instance of where we're starting to see the CRC really push back and say, your data reflects differently, we're relying on the data, right? And this is even before civil money penalties have really taken off the ground. So it's really imperative to make sure that that data is accurate. Also, as Mark has indicated, the contractors are adhering very closely to these dispute deadlines. So if something is referred over to Treasury, or if it's not disputed within the allotted time period, the contractors are saying, hey, you've had your opportunity pursuant to the statutory timeframes, go ahead and appeal your dispute through the proper formal appeals process, which can be burdensome, right? It's more ideal to be able to handle it directly with the contractor, using the informal dispute process rather than having to go through the formal process and the potential delays and issues that can result from that. So just keep that in mind. Best practices is to make sure that you adhere to those dispute deadlines. And as a result of both of those instances, we continue to see increased referrals to Treasury, which can be problematic with what Treasury can do with the debt once it arrives there. And I didn't previously mention it before, but there's this concept of where, especially in workers' compensation claims, if there's a denied component of it or the whole claim is denied itself, you're dealing with the CRC, you've been able to successfully dispute it, the CRC issues a closure letter, you think you've gotten the final demand and resolved it. Once the claim settles, TPOC is reported, and the other contractor, the BCRC, will try to open up a claim for recovery against the beneficiary and against the settlement. So they're not pursuing the carrier self-insured for recovery, but instead they're trying to pursue just directly against the settlement itself. So that can be problematic, and our recommendation there is just to be aware that occur and have a plan in place if it does occur. And just kind of, along the same lines, talking about, best practices, making sure that you adhere to dispute deadlines, just understanding, the process and the best way to deal with conditional payments that the contractors are seeking recovery for that aren't related to the claim, that you can dispute. I mentioned previously the informal process is the easiest and the best for for the purposes of dealing with it and not having to go through the formal appeals process. Obviously, you want to make sure that one, you have all your evidence lined up. You want to make sure your Section 111 data is accurate, and you want to be clear in making sure that the reviewer at the contractor can understand every aspect of what you're trying to dispute, right? Because they're going to try to reject a dispute to the extent that they can. So you want to just make sure that you have all all your ducks in a row. If that doesn't work, you can always again go to the formal 5-level administrative appeals process that's listed up on the screen there. As far as the redetermination, that's just going back to the initial contractor to say, hey, you made a mistake. This is why. Please take another look at it, right? Sometimes that can work. If it doesn't, then that can be, you can refer or appeal it further to what they call the qualified independent contractor, or the QIC. It's a third party that's been hired by Medicare to review these independently. Oftentimes, we find that the QIC can essentially rubber stamp the contractor's decision. So again, that's why it's so important to make sure that to the extent that you can be successful at the informal level to do so. If you're not successful there, you can appeal it to the ALJ, which is an administrative law judge. The issue with that is that it can take a little while to obtain a hearing, so you want to make sure you factor that into your consideration if you go this route. In some cases, we've seen a hearing be scheduled 2 to 4 years after the actual initial request for an ALJ hearing. So again, the further you get down the administrative appeals process, the more difficult it can become from a process standpoint, even if you feel like you have a winning argument. From there, you can go to the Medicare Appeals Council, and then after that, you can file suit in federal court. Now, Mark, I wanted to kind of bring you in here to kind of talk about how the courts have viewed this process and making sure that you follow along the process and you can't kind of jump jump straight to like a particular level.
Yeah, that's exactly right. The first thing Sid mentioned a bit ago, the first part of that puzzle, Sid, is you're 100% correct. The timelines are important, number one, right? You can't miss them. If you miss them, the courts are unforgiving. Okay, on the timelines, once you get into like 2, 3, 4, 5, okay? But also, you can't jump the level. And I see a lot, and look, I'm not criticizing the lawyers who do it. I get it. These are actually great ideas. But a lot of times they'll file certain claims, like maybe they'll argue a constitutional issue or a due process issue with respect to Medicare's recovery claim. And their argument is, look, we should be allowed to go right to federal court because of X argument. And the courts routinely, since 1984, okay, based on a U.S. Supreme Court case from 84, pretty much protect the administrative process, not just CMSs, but other administrative processes. And there's this idea of having to properly exhaust the administrative appeals process. So you got to go through all the levels. Like Sid said, they take 3-4 years to get into level 3. You got to factor that into your calculus about if you want to challenge and how far you're willing to go. But Sid, that's what that blue box is about. Now, Sid, I want to contrast, and Sid did a wonderful job. There's no one better that does that A and B stuff than Sid, okay? He lives it with the files, okay? So, folks, the situation changed. Now, Sid was dealing with a claimant who had the benefits, the government benefits, the Medicare benefits through the Part A and B program. But Sid, let me talk to the audience a little bit now. How this changes when we talk about Medicare Advantage. Look, number one, everything Sid just talked about CRC, BCRC, and all that type of stuff doesn't apply when we get into Medicare Advantage plans. Completely different world, a completely different process, okay? So now let's pretend that the claimant has the benefits through the Medicare Advantage plan. I already told you, these are private Medicare insured. There's over 3,200 different plans in the country. Congress set it up this way. They wanted competitions between private insurance carriers to foster innovation, provide better benefit options for the claimant. Look to the bottom right bubble. 39%, it's actually 42% now. 42% of the Medicare beneficiaries in the country are now on a Medicare Advantage plan. Why? They like the plan, number one, okay? Secondly, they typically offer more than what the government plan provides. So if you need something the government plan, Medicare doesn't provide, you're going to go to the Medicare Advantage plan. And then Sid, no doubt, number 3. We joke about this every session, and I got the TV on mute over there. I guarantee it. Joe Namath's been on, Joan London, Mike Ditka, or the latest, and Sid doesn't remember this guy, JJ from Good Times. Okay, I was a little kid. Okay, but these celebrities are out there doing these commercials telling people to call the Medicare hotline. They're basically saying, call and get yourself a Medicare Advantage plan. Let's look at the next slide of the country. Focus in on Texas. You are in the red. That means you, along with 18 other states and Puerto Rico, have rates of Medicare Advantage enrollees greater than 40%. Okay, so you have a lot of Medicare Advantage enrollees in your state. Next slide. Who are these Medicare Advantage providers? The big ones, United Healthcare, Humana. Blue Cross Blue Shield a little bit behind. But each region has stronger regional players. My mom up in Connecticut, she has Connecticut. That's very strong in Connecticut. Doesn't even make my circle here, right? But they're very strong in Connecticut. Remember, each Medicare Advantage plan could have 25, 30, 50 plans underneath their umbrella, purposely to provide the beneficiary with different options. Now, for you and I, as practitioners, the question on the next slide becomes, do these Medicare Advantage plans have recovery rights? Now, they do underneath the Medicare Advantage statutes. The statutes talk about how they may bill or they may charge for reimbursement against the claimant or the insurance carriers. The bigger question, because sometimes those are wobbly concepts that I just mentioned on a state level, the bigger concept or the bigger question is, can these Medicare Advantage plans also sue insurance carriers and maybe others for double damages? The answer is that depends on the jurisdiction. And on the next slide, the answer is in Texas, the answer is yes, they can. Okay? The states that are in yellow are U.S. District Court decisions. The states that are in red are U.S. Circuit Court of Appeal decisions. Okay? And in each one of these red and yellow states, the courts have allowed the Medicare Advantage plans to pursue lawsuits for double damages against insurers. You have 2 cases in Texas. You have a third one in Texas where they actually allowed the lawsuit also to go against a plaintiff law firm. So Texas joins Virginia, which also says they can sue the plaintiff law firms. Okay, so there is authority in Texas that these Medicare Advantage plans can sue for double damages, just like the government can. So you must pay attention. In 2 of these jurisdictions, the 11th Circuit, red, and Connecticut, yellow, U.S. District Court, these are 2 courts that took it a step further and actually whacked the insurance carriers for double damages. So you have to be careful. Now, on the next slide, the issues we have are identifying whether or not the plaintiff is on Medicare, what type of Medicare the person has. Right now, the Section 111 query, that process the RRE uses to determine the Medicare status, simply tells us yes on Medicare, no, not on Medicare. It doesn't tell us the type, doesn't tell us Part A or Part B, Part C or Part D, right? So many in the insurer community said, man, we got to change. We got to get a law that changes this so we're aware, we can easily identify this so we can get ahead of it all so we don't get sued for double damages. That's the PAID Act, and that's coming up, okay, in a minute, okay? And of course, as part of your plan right now, up until December, you'll see why in a minute, if you want to know that the type of Medicare the claimant has, you have to ask him or her or his lawyer. Right now, there's no centralized database. Coming soon to a theater near you, but we're not quite there, okay? So you have to develop that type of protocol. And then, of course, you have to figure out who's going to be responsible for reimbursing the lien, how you're going to do the settlement language. So I gave an introduction, Sid, to the PAID Act. The PAID Act is going to help correct what I just talked about. The PAID Act goes live in December of this year, December 11, 2021. The PAID Act impacts what I just discussed, Medicare Advantage plans. It also impacts Part D. We haven't talked a lot about Part D, prescription drugs. Do they have lien rights, their recovery rights? Yeah, based on the statutory wording, they do. Okay, have they been active in pursuing them? No. Okay, but you have the same problem with Part D as you have with C right now. You can't easily identify which plan the claimant is on unless you're asking him or her and he or she is giving you the accurate information, right? So this, as I mentioned, prompted people to galvanize up in Washington and get a new law passed called, on the next screen, the PAID Act, which was passed last December. Don't look at the words, just listen to what I'm going to say, okay? The PAID Act requires CMS to do something, okay? Requires CMS to do exactly what I just told you, to expand the Section 111 query process to return to the insurance carriers, the RREs, okay, the self-insurers, et cetera, okay, information about the person's Medicare benefits. Look at the next slide. Check it out on the left. The PAID Act actually only requires CMS to give you the name and address of the Part C Medicare Advantage Plan and or Part D Medicare prescription plan that the claimant may be in currently and for the preceding 3 years. Okay, that's all the law requires, which isn't bad in and of itself. But check it out on the right. CMS, in a rare instance of generosity, going to actually provide the RRE community with more information than is actually required. Study the green with me. Check it out. They're going to give you the contract number, contract name, the coordination of benefits address for the Medicare Advantage and Part D plan, and the entitlement dates for the last 3 years for Medicare Part C and D. This, folks, is huge. Not only that, but it's like an info commercial, Sid, but there's more. CMS actually went further. They're also going to provide us with the most recent Part A and Part B entitlement dates. So think about what we're saying, Sid. You're going to get info on A, B, C, and D. You're going to have all this info that you long probably needed to determine whether there's a recovery claim and do something about it, right? Sid, tell us on the next slide, the ostrich slide we call it. Talk about what this slide is talking about.
Yeah, so, all right, with the passage of the PAID Act, right, one of the main questions is, all right, now we're going to get all this information, this newer information through the query process. Like, what should we do with it, right? What are we required to do with it? So what the PAID Act doesn't do is require, an RRE to take that information and necessarily do anything with it. It just compels Medicare to provide this additional information. But as Mark has illustrated on, that previous slide with the map on it, there's certain states that have already established that Medicare Advantage plans can recover and can recover for double damages, Texas being one of them. And really the prevailing trend is that, more and more states are finding in favor of Medicare Advantage plan recovery under the Medicare secondary payer statute. So, as far as, how we feel about it and what we've been advising, folks with respect to the utilization of this data is that, we believe in proactive handling. So to the extent that you're receiving this information, we do advocate for, being proactive, reaching out, identifying if there's something out there. So if and when you do settle a claim, whether or not it's a liability, work comp claim, that you're not worried about a Medicare Advantage plan down the road popping up and trying to seek recovery. At some point, if it is, if they do make payment that's related to the claim, it likely is something that they might be, that they would be able to recover, whether it's through the MSP statute or through the Medicare Advantage plan statute. Best practices is to be proactive if possible. Now, understandably, you can certainly determine what your risk tolerance is there and develop your plans accordingly. But just understand, with that information available, you can take proactive action.
Thank you, Sid. And keep an eye out on time. And it's always my fault because I get too excited about this stuff. I really got to get a life. But let's go to the next slide and talk to us. High level, what do folks need to know about the future medicals or the MSA aspect in Texas? Let's call it that.
Yeah, at a high level, right? We know in Texas that they're non-subscriber states, so employers can opt out of carrying workers' compensation coverage, right? So in those situations, we really view non-subscriber claims as liability claims, right? It's really, litigated under that paradigm minus some defenses that would otherwise be available to you. So in that regard, we look at the requirement or a recommendation for a Medicare set aside very similar to how we would view it in the context of a liability claim. And if you look at what Medicare has rolled out, they've really provided very limited information, right? So this, you can see it on the screen there. There's the Sally Salcup memo from 2011, which essentially indicates that Medicare doesn't have a process for liability claims. However, the parties and the plaintiff's attorney should consider whether or not future medicals is involved with respect to the settlement, and if so, to consider Medicare's interest with respect to that. But they don't really put any criteria or requirements around it. Similarly, the regional memo from Texas that's listed there doesn't really provide any additional information, just that if there is a liability claim, there is a liability settlement, and the treating physician indicates that there's no need for future medical, there's no need to do a liability MSA, right? So thanks a lot, Medicare. Really a lot of special guidance there. But ultimately, the way that we've kind of distilled it down is this, right? Is that one, there's no process for the review and approval of a liability Medicare set aside. That liability claims are very different from the handling of a work comp claim, where if a claim is accepted under a workers' compensation coverage, there is specific benefits that are provided. Along with that is future medical coverage. Liability claims isn't established that way, right? If there's a judgment perhaps or a jury award, you might have that indicated, but for the most part, liability claims, if they're settled, it's under a disputed basis. There's no establishment of future medical. So the way that we look at it is this, is that we generally don't recommend a liability Medicare set aside unless the parties really feel, and especially, this is typically plaintiffs driven, the plaintiff feels that they want a liability Medicare set aside allocated to protect the possibility of Medicare denying benefits down the road. Or if there's a significant injury where the parties really feel that a liability Medicare set aside would be beneficial in that case, such as a significant TBI injury or a significant or a paraplegic case, or something of that sort, where there's significant injuries that the parties would feel better about it. So just think about it from the context of that. Again, it's usually driven by the plaintiff claimant. But at this current stage in the game, there isn't a requirement to allocate or submit a liability MSA to CMS for review. So right. Some other things. Now, yeah, go ahead. Yeah.
Oh, no, go right ahead. Yeah.
I was just gonna move down the line and just kind of talk about some of the other compliance points that would be considered as part of the non-subscriber context as well. Obviously, with Section 111 reporting, if it's a liability claim, you're generally not establishing ORM, right? We mentioned that that's really for work comp, no-fault claims. If it's viewed under a liability paradigm, you haven't accepted, ongoing responsibility for medicals, we would not, be reporting ORM as yes. And then as far as conditional payments are concerned, that's handled as previously discussed, not necessarily through the CRC, but because it's viewed like a liability claim through the BCRC and the process is handled there. Yeah. Mark, you were going to say something?
Yeah, I was going to say, on that liability MSA thing, it's a complete mess, as you got the picture from Sid, right? There's no direction on it. So, Sid, I think on the next slide, we have an update, sort of. CMS keeps talking about, if you look on the next slide, they keep talking about clarifying for us, there it is, clarifying for us the whole liability MSA issue, right? Which obviously in Texas affects liability claims, right? Affects these non-subscriber claims, et cetera. Look, the bottom line's in the yellow, all right, down at the bottom. We're waiting for CMS's proposals on this. We've been waiting for 4 years or 7 years, I guess, depending on how you're counting, right? They have told us that they are going to release them next month in October. Who knows, right? They keep pushing back the date for the last 4 or 5 years. So we don't know right now. We'll let you know. We'll have tons of articles on that. But right now, they did a wonderful job telling you what the current status is, which is a mess. Okay, next slide, Sid. Let's have you come in before we go to quick Q&A. Don't worry about that. We pretty much told them. Sid, close us out before we get it back to Mandy and Diane. Just real quick, this idea of developing a Medicare game plan. What are the takeaways today?
Yeah, well, I mean, we went through a lot of items here, right? But really, when we think about a game plan, we always start with, first of all, foremost, you know, have a plan in place, right? Have a plan to identify whether or not you're dealing with a Medicare beneficiary and what the particular issues that might arise is. We already talked about, you know, making sure you're reporting, making sure that you're considering conditional payments, and making sure that you consider the future medical component if relevant, right? Establish what your criteria is, establish what your protocols are, and then, you know, I mentioned previously, like we advocate for deploying proactive strategies, right? So when we're talking about, you know, conditional payment recovery, you know, making sure that, you know, that's part of the settlement process, right? Part of the discussions with the party, making sure that you you adhere to the timeframes that are involved, trying to get involved when you know as early as possible that you have a Medicare beneficiary. Similarly, with the liability Medicare set-asides in non-subscriber cases, or you know, even in a work comp case, if they you know, if they are receiving coverage through workers' compensation benefits, to understand, like, when are we going to do a liability MSA? When are we going to do an MSA? How does that look? You know, what does the treatment look like? How can we mitigate that exposure down the road? And having that plan in place so you can just, you know, move down the line, you know, when you approach settlement. So just, you know, from a high level view, just understanding what that exposure is and having a game plan in place to address that.
Thanks, Sid. Mandy, let's have you come back in here, and let's see, and Diane also, if we have any questions.
Yes, we had 3 questions. So the first one, I think it's for Mark. What do you see as the biggest challenge dealing with Medicare compliance?
Exactly what Sid just talked about, what's on the screen, developing a Medicare game plan, not having a plan in place to identify the issues and having a proactive strategy to address it. In Texas, if I go a little bit, you know, from another angle, keeping in mind that, you know, you may be in a form of insurance where maybe you're not going to settle, say, a workers' compensation case, but as Sid showed you, you still have that potential exposure on conditional payments with the CRC, so don't ignore it, okay? So that would be one facet that I would include on that.
Okay. Question number 2. What impact do you think the PAID Act will have overall?
I'll do that one, Sid. And Sid, you don't mind, just forward it one slide. Folks can see our contact information. Yeah, I think overall, folks that have been worried about being sued for double damages, folks that have been sued for double damages and seeing the increase of Medicare Advantage recovery claims, I think this will increase activity from the insurer side to make sure the Medicare Advantage issue and Part D are addressed. As Sid mentioned, you will have, come December 11th, all the information you need to spearhead it. You won't need to rely on the plaintiff and the plaintiff's lawyer anymore. You will have it through CMS.
Thank you. Question number 3 was really meant for probably all of us. Will we get a recorded copy of this webinar? And I could probably answer that, no, but you can see it again on the Macro Pro YouTube channel. Maybe I can have Diane chime in and give us that link. Otherwise,
yeah, Mandy, once this program is finished and recorded, I will be taking it, downloading it onto my system and up onto the YouTube. So hopefully they can have it as soon as later this afternoon. But it's a great program. It certainly has so much information that it is going to be worth reviewing again and again to make sure you catch all the nuggets and all the important information. And as a reminder, there are great handouts attached to this webinar. So if you haven't yet done that, please download the information from our speakers and from MacroPro so that you have it for future reference. I'd like to thank all of our speakers for doing a phenomenal job. Mark and Sid, you always educate our industry so well, and we appreciate your expertise. Mandy and Tom, appreciate you joining me today. And all of you out there in Texas, we want to say yeehaw, and we certainly hope to see you again soon. Bye-bye now.
Thanks,
All right.
everyone.
All right, thank you.
Bye, thank you.